Good evening. This is Heather Van Wild with Raindrop Works, coming to you live in Portland as we take a look at some information on some recent cases that have been going on. There's a particular focus tonight in a case involving Andy Ngo, which is, as some of you may know, a fairly well-known conservative journalist in the Portland area. He's been featured on places like Fox News, as well as some interviews and such on Capitol Hill. He is definitely best known around here for his reporting, putting anti-fascist and other affiliated groups in a very negative light for his viewers. So what started a lot of this is last year he attended a protest that had anti-fascist people in Black Bloc, where he alleges that he was injured. And he has opened up a lawsuit against Rose City Antifa, as well as a number of individuals that he says directly assaulted and later harassed him at his home. A few weeks ago, he made news again, or more correctly, made news himself, after succeeding at having a motion to dismiss part of the case that he filed was denied, meaning that it'll go on to a full trial before a jury. And he took that as a large win, as I think we'll see going forward with this information later today. It wasn't the clean-cut victory that he makes it out to be. Okay. So the first thing I want to do here is just taking a look at the case itself. And I waited to log in because this likes to log me out quite quickly if I'm not careful. Okay. So the case itself is Andy Ngo, and he is suing Rose City Antifa, which is a anti-fascist group in the Portland area, as well as a number of individuals. He alleges actions by John Hacker, Joseph Evans, Catherine Bolen, and Benjamin Bolen and Madison Allen. So far, we've only really heard anything from Mr. Bolen, which is what the case that the order came out a couple weeks ago was about. Mr. Bolen essentially filed a anti-SLAPP motion, which is a strategic lawsuit against public participation. The idea behind anti-SLAPP laws and motions is somebody can theoretically file a lawsuit as a way to stifle criticism. Using the courts in that way is definitely a problem, and a number of states, not all of them, but a number of them, have created legislation that allows that if a lawsuit has been filed against someone because of a protected activity, that case could be potentially thrown out without the process of going through a lengthy trial. Mr. Bolen was attempted to use that, and as we'll see, he did fail at that, but it wasn't quite in the way that Andy Ngo made out in his online statements. Okay, and obviously now this case was first filed back in June. when Mr. No here filed charges alleging assault, battery, and emotional distress. We'll go ahead and take a quick look at that complaint here. Okay. He is suing, like I said, Rose City Antifa, which is an unincorporated association, Mr. Bolen, Mr. Hacker, Miss Balea, Mr. Evans, and I don't know if Madison Allen is male or female, so I apologize on that. He is suing them collectively for $900,000. His claim is that the people that he's suing have sought to suppress his activities through a coordinated pattern of violent, harassing, and stalking behavior. Defendant Rose City Antifa is an offshoot of Antifa, a group deemed a domestic terrorist group by the U.S. government. To my understanding, that has not actually been a thing. Yes, at the time, President Trump did say that he was considering Antifa a terrorist group, but I have not heard of that designation being applied by the FBI or any law enforcement agencies. Saying that they're widely known for its organized violence and riotous behavior. No, with his persistent reporting, has brought to light many misdeeds of this terrorist organization, and is perhaps more responsible than any other American journalist for increasing public awareness of the threat Antifa and its followers pose to public safety. In retaliation for No's unfavorable coverage and in an effort to intimidate him from further exposing illegal acts, he claims that defendants have targeted him, causing lasting and significant physical injuries, publicizing his personal and private information about his whereabouts and his family, and attempting to break into his family's home. He goes on to, his lawyer goes on to state that this is filed in Oregon because everyone involved and the events that he's saying happened are in Oregon, in Multnomah County specifically. He states Rose City Antifa is an association based in Portland, that they're an organized group of individuals which trains and directs the actions of its members. I don't know enough about the organization to be able to confirm that. I will say that from what I have seen in the last 6 months of his journalistic style, I would verify things that he says, including in these court filings, where the burden of proving your statements at this stage is not so much of an issue. All the individuals that he's suing are Oregon residents at the time that this happened. Plaintiff does not know the legal name of defendants does 1 through 50. This is a normal thing where if you think there might be something else coming up or somebody else needs to get sued, but you don't know who yet, you can leave those in to be able to amend the case later. No. So here, Mr. No, he acknowledges that, he's best known for his news coverage of Antifa. Says they're an extremist movement, organization of far-left violent individuals with militant opposition to the government. And people are perceived as right-wing, calling for insurrectional anarchy to overthrow the American government. My experience with Antifa, that's a very broad generalization. Members engage in rioting, property destruction, armed brawls with political opponents and bystanders, or journalists perceived to be allies of their opponents. He's setting up why he was targeted, according to him, later. According to Antifa, any violence against public demonstrations by group they view as fascist, racist, xenophobic, homophobic, conservative, or right-wing is inherently self-defense, irrespective of whether such groups actually subscribe to these views, because such public demonstrations purportedly lead to violence against marginalized groups. Despite Antifa's self-indulgent proclamations of protecting minority groups, defendants who, upon information and belief, are members of or are closely affiliated with Antifa have targeted him, a journalist who is of Asian descent and gay, for his unfavorable news coverage of them. I will say, when I saw this, I laughed, because as a trans person, to try to say that, oh, I'm above criticism by your group because I happen to share traits in common with your group, is very disingenuous. Yeah. Being trans does not, or being gay and Asian in this case, does not mean that you are immune to criticism. It says, defendants and their fellow members or supporters and allies have physically accosted and viciously assaulted No at protests that he was covering, stolen his photographic equipment, publicized the address of his family home and mother's business, tried to force entry into his house, and stalked him in his personal life, including by attacking and stealing his phone while at a gym. It says that Rose City Antifa is the Portland chapter of Antifa. I don't know of anything to verify that. The best that I know is, not really, they're a loose group of unaffiliated people. He's claiming that they constitute a racketeering enterprise, the meaning of Oregon statutes. You'll find that so far in this case, not much has happened with Rose City Antifa. Looking at court records, somebody was served papers that supposedly was an agent of Rose City Antifa, but court records say that it was not the party that was served. So at this point, it appears that officially Rose City Antifa has not been served in this case. So there is very little that can go against them at this point. There was mention of popular mobilization, also called Pop Mob, who supposedly is purportedly not as violent as Rose City Antifa, but still engages in activities to counter perceived fascist and racist protests, sharing leadership and members and the groups collaborate. So this is about an event that happened in May of 2019, so a full 13 months before the events of George Floyd and the current protests that are going on. He was covering demonstrations promoting May Day in Portland. Says that he was set upon by mask-clad Rose City Antifa members and others, stating that among them was Defendant Bolen, heavyset white man sporting a brimmed black beanie, white frame sunglasses, dark bandana with white patterning, and black gloves with hard extensions near the knuckle area, carries a distinctive skateboard. And then he has a picture of this supposed person. This is going to be a significant part that comes up later, because a lot of what's happened so far has specifically dealt with Mr. Bolen. He states that Mr. Bolen struck him in the abdomen with a fist, causing pain, and that he feared for his safety. And then he fell away into the crowd at the ICE building in downtown Portland. And states that he left the area of the attack, went to cover a demonstration by Patriot Prayer against Antifa near a northeast Portland bar called Cider Riot, which at the time was frequented by Rose City Antifa members and their supporters. Interestingly enough, I have to make absolutely sure, but there is currently a set of cases going on against Joey Gibson and a number of members of Patriot Prayer that are related to events that took place at Cider Riot, and I believe this is the same day where members of Patriot Prayer have been charged with riots. Some of them have already pled guilty, some are still fighting their cases. Then there are allegations about a verbal confrontation between Patriot Prayer and Rose City Antifa, where a street fight started, and that while he was recording the events, a person here sprayed him in the face and eyes with bear mace, and he believes that this person was part of Rose City Antifa without really giving any way to prove it other than they were there. The attack left him temporarily blinded and caused him to fear for his safety that he might be further threatened or attacked. It caused him severe pain, humiliation, and emotional distress. Bear spray is... first off, bear spray is actually not allowed to be used in Portland city limits. It's too large of a pepper spray container to be carried, and I mean that's really neither here nor there, but it is, pepper spray that is going to debilitate. And he alleges, a week later, that somebody, he states John Hacker, threw an unknown liquid onto his head while he was at a local gym, supposedly trying to frighten or intimidate him. He tried to record the incident with his phone, and supposedly the phone was taken until gym staff intervened and returned the phone. And we go forward another month and a half to June 29th. More protests arose, facing off against conservative protesters. In 2019, we had a lot of right-wing protests that happened in the downtown Portland area, which caused leftist protesters to come out to counter-protest. Here, in the first event, Rose City Antifa members and others, including Does 2 through 20, lobbed containers full of liquid, purportedly milkshakes they had acquired from Pop Mob, and other unknown liquids at No. This is the genesis of the infamous milkshake story about Andy No. Portland police had issued a warning on social media that the milkshakes may have contained quick-drying concrete. Essentially, Portland police got a tip from somebody suggesting this pop-up milkshake stand that a group of people had put up in downtown. They were adding concrete to the milkshakes. There was no evidence to support this. And, yeah, supposedly he was, as you can see in this picture down here, somebody did seem to throw a milkshake at him, and he got whipped. Dairy whipped. But again, later on there was no evidence found that there was any concrete in any milkshakes. People were eating them or drinking, however you would describe consuming a milkshake. He claims that this person was one of the ones that was throwing a milkshake at him. Says police took a crime report but refused to confront the alleged suspect. He then alleges that he was mobbed and bloodied by more Rose City Antifa members who threw more milkshakes, eggs, and containers and punched and kicked him. That he was hit in the head with plywood signs and tactical gloves. He claims that one of them had he got a license plate for one person, as well as a whole bunch of other things. Multiple pictures of suspected or alleged instances that his GoPro camera was stolen that day because he had dropped it. He says he was able to break away and requested assistance from the medic team associated with Portland Police, and police medics directed him to the Central Police Precinct, the same area where he was just beaten. He walked towards the police precinct and was taken to OHSU, and after testing was diagnosed with a subarachnoid brain hemorrhage and hospitalized overnight. I will say, having documented leftist protests in Portland over the last few months, and say the police medics do not seem to care much about treating people that are injured. These brain hemorrhages that he's talking about, he claims, is because of the concrete-laced milkshakes that were thrown at him. And so far we have not seen any evidence that this actually happened. Now, if this does proceed to a full trial, I'm sure some redacted form of this information will be available as part of the evidence. I don't know how much we as the public will get to see, but we'll find out what happens later. Fast forward now to Halloween of 2019. It states that at least 6 masked Antifa members, including those 45 through 50, approached his family home and stood outside the door. Each of their masks bore a printout of Andy No's face, where they banged on his windows, rang the doorbell, and tried to gain entry by trying the door handle to see if the door was locked or not. They weren't carrying trick-or-treat bags, and he thinks that they were there just to harass him. Obviously, he got pictures of people wearing Andy No masks. Obviously, this means that, somebody knew where he lived, and then also information about his mother's small business had been released publicly, which I believe is some sort of a dry cleaning shop. He then also says that there was more doxing that had happened, which I'm sure there will be information of that coming later. And then a lot of the rest of the complaint, it just goes through the legal standards for the claims that he's saying. He's saying that he's suffered harm, has severe pain, inconvenience, and interference with everyday activities, and he needed medical care and ongoing treatment. It's a lot of kind of standard stuff that comes from these lawsuits. And as expected, they got logged out. Luckily, he only has this one case here, so it's easy to find. Now again, I said before, according to the court records, Rose City Antifa is still unserved. There is a note about somebody that was given paperwork, but it was marked as a non-party. A lot of actions about intent to take defaults against people, which did not happen then. Basically, if somebody is sued, somebody's sued and they're given paperwork, they have a certain amount of time to respond, or you can file a default judgment, which is you automatically win. Nobody has come forward to say this is not correct, so everything you say is taken as fact. At which point we come forward to September 21st, where there is a motion to strike that is filed by, I believe this one is part of, yes, Mr. Bolen. He states here that the plaintiff is a well-known right-wing provocateur, agitator, political pundit, and social media personality who publicly and stridently opposes the Black Lives Matter movement and anti-fascists, brings suit against Rose City Antifa, 50 unnamed does, and 5 individuals he asserts are members of Antifa. It appears he seeks to hold all defendants jointly liable through association based on their political beliefs, namely their opposition to fascism. What they mean by jointly liable in this case is, remember, Andy No is suing for $900,000. When it is done jointly, it doesn't matter who pays into that $900,000 among the people that have been sued. It all goes towards that same amount until it's paid off. So one person could pay all $900,000 and nobody else pays anything, or it basically, everyone that loses the case has to work out among themselves how they're going to satisfy that. Well, he alleges that people dressed in black clothing, who he assumes are members of Antifa, have battered, assaulted, or intimidated him on several separate instances, and therefore all defendants are jointly liable for $900,000 in damages. The only allegation plaintiff includes against Mr. Bolen is that he purportedly punched plaintiff in the stomach at a political rally on May 1st, 2019. He includes a photo in the complaint of the person he says punched him and who plaintiff alleges is Mr. Bolen. Not only, here is where things start to get crazy. Not only is the person in the complaint not Mr. Bolen, but Mr. Bolen has never punched Mr. No. Mr. No is aware that Mr. Bolen holds anti-fascist views and that he exercises his First Amendment right to assemble and petition the government for a redress of grievances. Mr. No disagrees with Mr. Bolen's political views and seeks to hold him liable because of those political views. This is precisely the type of claim that the Anti-SLAPP statute is designed to prevent. And again, this is where this case, eventually this anti-SLAPP claim does get denied, which Mr. No sees as a win. As you'll see later when we go over the judge's decision, it's not as clear-cut a win. They actually end up giving the game away here right now anyway. While the conduct in the complaint regarding Mr. Bolen is an alleged punch and therefore not itself protected speech, defendant submits that this motion is appropriate because Mr. Bolen did not punch plaintiff and because plaintiff has named Mr. Bolen as a defendant based on his political views and his attendance at an anti-fascist political rally. He doesn't care if he misidentifies a defendant so long as that defendant is someone Mr. No believes to be an anti-fascist. At the end of the day, what the judge ended up saying, and you'll see more when we go into her order, is that she couldn't make the ruling on the decision of if it was actually Mr. Bolen or not. And you'll see photographic evidence to explain some of this later. And since they have agreed, yes, it was the alleged punch that was the cause of the suit, not that he was at the protest, assaulting someone is not protected, so it doesn't fall under being able to go to an anti-SLAPP motion. Eventually it'll be up to a jury to decide, was it Mr. Bolen that allegedly punched Mr. No? Okay, so then we go forward. He moves for a judgment, striking the plaintiff's claims because he named him as defendant of the action because of his presence. He says that the only burden, or he can't meet the burden of proving the claim because his allegation is based on misidentification. He didn't punch Mr. No, so he can't be held liable simply because of his political views or his presence at the rally or protest. Judges in a trial like this can only rule on matters of law. Does the law say that this is correct or incorrect? Identifying someone is not something that the law can do. It has to be done by a jury. And that's why the judge couldn't rule on that. Then they go on further to give some more information explaining this. Antifa, short for anti-fascist, being a loose collection of groups, networks, and individuals who believe in active, aggressive opposition to far-right-wing movements. Their ideology is rooted in the assumption that the Nazi Party would never have been able to come to power in Germany if people had more aggressively fought them in the streets in the 1920s and 30s. It's actually a broad term for a person or group actively opposing fascism or an anti-fascist movement, and was coined back in the 1930s. As FBI Director Christopher Wray said during House Committee on Homeland Security in September of 2020, Antifa is not a group or an organization, it's a movement or an ideology. While the president and his supporters characterize Antifa as a domestic terrorist organization to further their agendas and push their election year narratives, federal law enforcement authorities do not. They have never actually said Antifa is a terrorist organization. As a result, Antifa has become a right-wing boogeyman and the subject of a misinformation campaign used to oppose Black Lives Matter movement and progressive leftist policies in the United States. This misinformation campaign has increased in its intensity this year, in part due to the presidential election, in part due to opposition to the Black Lives Matter movement, which has seen a significant increase in activity since the highly publicized murder of George Floyd by police officers in Minneapolis. Most recently, conservative political pundits attempt to spread misinformation blaming Antifa for the wildfires raging in the western United States, spreading fear and putting people, including first responders, in harm's way because armed groups of civilians were convinced by the misinformation that Antifa was setting fire to their properties or looting. And this was something that we had in the Portland area. Just south of here, we had the fires that got dangerously close to the main city and caused devastating damage. We had independent journalists that were held at gunpoint because militant people were setting up illegal checkpoints, and it was definitely causing a lot of problems. Now, anti-fascists are known to wear black clothing from head to toe. This practice is known as Black Bloc and originated in protests against police brutality, white nationalism, and neo-Nazism in West Germany in the 1980s. It is now employed by anti-fascists and other political groups around the world. The reason for the practice is anonymity. While it may seem at first that the desire for anonymity has some nefarious or even criminal purposes, members dress in black and mask up to avoid being doxxed and become the target of white nationalist or white supremacist terror campaigns or even violence. And this is something that we have actually seen Mr. No himself, I can't say dox so much, but in the early protest days after George Floyd's murder, he definitely had a tendency to, whenever police would arrest someone at a protest, we may not have seen their faces because they were in block at the time, but when they would be booked into county jail, their mugshots would be publicly posted on the county website. And he would go and pull their name and the alleged charges and their picture and put them up on his Twitter feed so that anybody looking at his feed can see this person was arrested. Part of the problem is an arrest is not a conviction. In our country, we are innocent until proven guilty by a jury of our peers. Unfortunately, we also have trial by mob, where now that these people's names and pictures are out, somebody might figure out, oh, well, here's where this person works. Let's go harass them at the job. Or try to get them fired. And this is something that both sides have done when there's ideological questions. The appropriateness of that is a whole different topic, though. Yeah. So, that being said, if the subject of the protests is oppressive state actors or white nationalists, it is important that the protesters remain anonymous and united for their own safety. They then go on to claim that Andy No is a right-wing provocateur, right-wing media pundit, agitator, and social media personality. He's a Portland resident and currently an editor or contributor for conservative Canadian online news magazine, The Post-Millennial, which focuses on politics and culture and contains primarily opinion content in the form of recycled news stories with conservative editorializing added. It has been criticized as a conservative pamphleteering organization and not a news site. Its editors have also been criticized for giving platforms to white nationalists and white supremacists. And you'll find later on a number of these statements are going to be stricken from the official record, probably for relevance to the current case. I'll say, before working for Post-Millennial, Mr. No was a contributor for another right-wing online magazine, Colette. Mr. No left that position immediately after publication of the video showing Mr. No with the Proud Boys as they planned their attack on leftists at Cider Riot in southeast Portland on May 1st, 2019. That's the case where he says that Mr. Bolen punched him and then later on went to cover a second protest at Cider Riot, the one that there are now riot charges against members of Patriot Prayer that we're also following. So before working for Colette, Mr. No was an editor for Vanguard, the student newspaper at Portland State University. He was terminated from his position there for ethical violations that the university found put people in danger. Basically, his entire journalistic career, he's been documenting for organizations that are being found to be questionable. And the conservative outlets that have a focus on white nationalist or extremist positions. The people he put in danger while working for Vanguard are Muslim. Before his fixation with Antifa, Mr. No focuses energy on maligning Muslims. He's become a celebrity among right-wing conservatives and now makes appearances on Fox News. He was recently invited by Senator Ted Cruz to give testimony to the Senate Foreign Relations Committee to discuss alleged anarchist violence. He and his online content have been weaponized by conservatives during this election cycle. They use him and his content to push a narrative that opposes the Black Lives Matter movement and trivializes the rise in white nationalism and white supremacist violence in the United States by framing Antifa as the real threat to American democracy. He's frequently retweeted and amplified by conservative politicians, including the president, who use his material to push the Trump campaign message that if Joe Biden wins the election, spoiler, he does, then small towns and suburbs will be in danger from marauding criminals, which is how the president describes Antifa or advocates of the Black Lives Matter movement. Spoiler alert, I don't see that happening. The president opposed to the Black Lives Matter movement refers to teaching children about the history of slavery and racism in America as child abuse, and considers the 1619 Project a New York Times project that teaches people about systemic racism in the country's history by examining the consequences of slavery, toxic propaganda, and ideological poison that, if not removed, will dissolve the civic bonds that tie us together and will destroy our country. Mr. No helps him and his supporters push this narrative. He provides Trump and his supporters with prepackaged, ready-to-consume media content, or rage bait, that furthers this message and appeals to the demographic of the president's supporters. His content is perfectly suited for this purpose. He peddles in riot porn, that is, videos that are edited, decontextualized, and shared among audiences hungry for a new fix of riot porn, which instantly goes viral across the right-wing media ecosystem with the aid of influential pundits and politicians, including President Donald Trump. Over the summer, we've seen many instances of him actively taking video from other journalists and retweaking the story to shift the focus from the anti-police protests to how dare somebody do this to our beloved police. Now, the way that Mr. No produces content is by appearing at political rallies attended by leftists to dox leftist attendees, which means uncover their identity and then publicly post personal identifying information online so white nationalists or other right-wing groups can access the information, use it to target leftists and their families with harassment, threats, and sometimes even violence. in the latest string of protests, he hasn't been out in person as much because of the fact that more people will recognize him, and that does put him at risk because he's lost his advantage of anonymity himself. So some have legitimately accused him of creating white nationalist kill lists. He is also well known locally and nationally for creatively and deceptively editing his videos in a manner that makes it look like leftists are the violent instigators. In addition to doxing leftists, he appears at these rallies to agitate attendees to allow him to create more of his carefully edited videos he uses to solicit donations and to malign anti-fascists. It's well known to people who attend rallies in Portland, Oregon, that this is what he does. Because of this, he is nearly universally reviled by many who attend these rallies and who oppose the administration's policies, fascism, or white nationalism. His appearance at the rallies nearly always draws boos, jeers, and contempt from the crowd. He is sometimes pushed, punched, or had things thrown at him from many people in the crowd. He feeds on the attention even if it's negative. While he's booed or jeered, he continues his attempts to unmask or identify members in the crowd and then posts this personal identifying information online for white nationalist groups to consume. Right-wing, local, and national political figures and pundits then shine a spotlight on him, which he uses to sell his books or to drive viewers to his online content, and once there, he solicits donations. He raises money online by getting as much attention as he can, so he attends the rallies and provokes confrontations with people in the crowd to provide him material to post online to get more views and more donations. He's raised hundreds of thousands of dollars using this method. On a single GoFundMe fundraiser, he made close to $200,000. And he has many of these fundraisers, potentially dozens. Indeed, he's using this lawsuit as a means to raise money. And they actually do show... I'm going to actually take a look at that particular link. Yeah, so we have the Dillon Law Group. Who is raising money here, saying that the police refused to intervene, arrested no one despite extensive video evidence. Saying that his tax-deductible contributions will directly fund bringing them to justice. As well as vague threats of suing the government officials as well for their inaction. A whole bunch of videos and such where he talking about what's happened to him. And I do believe, I would have to double check, but I believe this is the law group that is representing him in this case. So he is a strident opponent of Black Lives Matter movement and leftist politics, and has a quixotic fixation with Antifa. He believes that racially motivated crimes are hoaxes, much to the light of white nationalists and white supremacists. He posts dozens of tweets on Twitter nearly every day, and nearly every one of those tweets relates to Black Lives Matter or Antifa, and in particular posts reveal identifying information about people with whom he disagrees. The information in his tweets is presented in a manner designed to build hatred or resentment of leftist, Black Lives Matter supporters, and Antifa. He then posts identifying information on those posts so some of his rogue followers know who to target with their harassments and threats. Thank you, Corey. Many people, including Mr. Bolen, consider his tactics in this regard to amount to stochastic terrorism. That one's a hard one. By both demonizing leftists and posting their personal information online when he knows how this information is used. He masquerades as a journalist to lend him credibility and plausible deniability when one of his followers begins threatening or harassing his opponents. He knows the information is used to target his opponents, but he calls his work journalism and argues he can't be held responsible for what people do with the information he posts. He's engaged in this tactic since he was fired from the student newspaper at PSU for similar practices, which the university had found placed people in danger. He continues to place people in danger every single day and remains intransigent even when he is informed of how his content is being used to put people in danger. He has a working relationship with right-wing or white nationalist groups like the Proud Boys, Patriot Prayer, Three Percenters, and potentially automorphin. He has a practice of embedding with people from one of these groups and reaches agreements by them whereby they provide him protection while they instigate a skirmish or physical confrontation that Mr. No films and deceptively edits in a manner to further his agenda and his online content. This has also been documented both locally and nationally. And this is a particular point in the Cider riot cases dealing with Patriot Prayer, because he did show up with their group before they went to Cider riot and was with them when they were doing their documentation. With his fixation on leftists and Antifa, he repeatedly uses his online platform to publish misinformation in his attempt to malign Antifa. Following the mass shooting attack at a Walmart in El Paso, he was responsible for a misinformation campaign that attributed the attack to Antifa. His tweets were picked up by right-wing media outlets who then ran the story. The story was false and appears to have been created by him. This is a dangerous practice and the plaintiff knows it. He just does not care if people are harmed so long as he pushes his narrative and receives both attention and donations. Because it's so well known that he facilitates harassment and threats from white nationalist group targeting leftists, he is despised by most leftist protesters. He's immediately recognized by the crowd when he arrives, and is promptly booed, jeered, and harassed by people who legitimately, and for good reason, think he is there to put their lives in danger. They then go on to talk about Shane Burley, who is, I believe, another person who is being named in this case, but is as a journalist who covers far-right politics and the anti-fascist movement. He's familiar with Mr. No's tactics, has attended most of the rallies and protests over the last few years, including those described in Mr. No's complaint. And he's personally observed Mr. No's dangerous tactics and has been a victim of Mr. No himself. And a lot of what's happened here has revolved around Ben Bolen, Portland resident, graduate student at PSU, a PhD candidate in mechanical engineering, and he is politically engaged. He's a leftist on the political spectrum. He opposes fascism, and so is anti-fascist. Notwithstanding his anti-fascist beliefs, he is not a member or associated with Rose City Antifa, nor was he at any time in 2018 or 2019. He's deeply concerned with the current president administration's family separation policy, implemented by ICE and designed by white nationalist Stephen Miller. He finds this practice inhumane and unacceptable, strongly opposes many of the policies the current administration has either created or broadened, and attends political rallies and protests to raise awareness and voice his dissent. Mr. Bolen's personally witnessed Mr. No at rallies and docs leftist protesters online. It is well known both locally and nationally that this is what Mr. No does. Mr. No and his dangerous practice of doxing leftists are known by the people who attend the rallies and protests in Portland. Because of this, he's nearly universally reviled by those who attend the protests, and Mr. Bolen has personally witnessed it. He's witnessed Mr. No being jeered, booed, pushed, shoved, or punched by other people in the crowd. While he disagrees with Mr. No's politics and abhors his practice of putting people in danger, Mr. Bolen did not punch Mr. No on May 1st, 2019, or at any other date. And then they go into the protest itself with the alleged punch and the case that he's making a mistaken identity. On May 1st, there was a protest in downtown Portland by the ICE Detention Center. The target of the protest was the federal government's family separation policy or practice, in which the government forcibly separates members of families seeking to enter the United States as refugees or immigrants, and detains these people in deplorable and inhumane conditions. The protesters consider this practice unacceptable, indefensible, and at least quasi-fascist. Mr. Bolen did attend this protest. He was dressed in black clothing to protect his identity. Most of the attendees were dressed in a similar manner. Mr. No attended the rally, and Mr. Bolen saw him in attendance. Mr. No was met with jeers and derision, as he normally is at events like this. Mr. No alleges that he was set upon by mask-clad Rose City Antifa members and others. Ooh. Corey just said he was there. Corey Elliott is an amazing journalist. I am in awe. Um, yeah, so he alleges that Mr. Bolen was one of those people and that Mr. Bolen punched him. Mr. Bolen follows Mr. No's tweets and was able to piece together how Mr. No misidentified him as the person who allegedly punched Mr. No. On May 1st, he tweeted that he had been punched in the stomach by an unknown masked man. The following day, he posted on Twitter seeking help identifying the person who allegedly punched him. His Twitter post included a screen grab from video that depicts a person wearing all black with no identifying features shown whatsoever. In response to a tweet from Mr. No, a Twitter user named Some Based Guy tweeted at Mr. No stating that he was pretty sure that Mr. Bolen was the person who punched Mr. No based on the photograph in which no identifying characteristics can be seen. Some Based Guy includes pictures in that tweet of a man he says is Bolen and who appears to be dressed in a similar manner as the person Mr. No identified as the person who allegedly punched him. That is, both people are participating in Black Bloc protest. Mr. Bolen does not know the person who calls himself Some Based Guy on Twitter. Moreover, the person in the photos posted by Some Based Guy, who is the poster, which the poster states is Ben Bolen, is not in fact Ben Bolen. I'm going to go ahead and actually put up the picture of the tweet from Some Based Guy here. You can see here, these, after Mr. No posted a request for help identifying person the day after, this is what, as far as we know, some random person on the internet said, this is your guy. Okay. So he was dressed in a similar manner, but is not him. He appears older than Mr. Bolen, heavier than Mr. Bolen, and has shorter and lighter colored hair than Mr. Bolen, as well as different facial features. He states in his tweet that the photos depicting who he mistakenly identified as Mr. Bolen were taken in June and August of 2018. Mr. Bolen has provided photos from around that time period in his declaration showing that he is not the person in the tweet from Some Based Guy. And I've gone ahead and here are the pictures from that declaration. So I'm going to make this a little larger. As you can see, on the picture on the right-hand side is the person that Some Based Guy said was Mr. Bolen. The picture on the left is a picture that Mr. Bolen had taken a few weeks, supposedly about 5 weeks, separate from the two pictures. I can't make a legal decision, but I do tend to agree. The two people do not look alike to me. So, yeah. So, again, Mr. Bolen did not punch Mr. No, does not know who punched him, if he was punched as he alleged. If Mr. No was punched by a person wearing a black hoodie, black hat, black bandana, sunglasses, and black gloves at the protest downtown, it could have been any number of dozens or hundreds of attendees, because this is how most people at the protest dress. Then they go into the legal definitions. If you go and look at or listen to the audio of the hearing in front of the judge, they will talk about how Oregon modeled its anti-SLAPP statute on California's, which means when they look at court precedent for how to interpret anti-SLAPP laws, they do look at some of California's laws because California had their law done first and we copied theirs in Oregon. Also of note, the attorney that is representing Mr. No also happens to be from California, so that is a coincidence, but one that was interesting to me when I saw it. And they do say, regarding the first step, the court must determine whether the defendant that filed the motion met its prima facie or on the face burden to show that the claim arised out of conduct described as basically as protected. Unfortunately, in this case, the judge ended up deciding that because the claim was about the alleged punch, which is not protected activity, this didn't rise to a dismissal as a anti-SLAPP case. even though they did think that and okay, I also Corey, you did say the judge, if you think it's the right one, is shady. I don't know enough about the judge's past judicial information, but somebody did link me some information about that judge recently that does cause some concerns. They did make the claim, which I think is kind of the crux of the matter here. The court should not permit plaintiff to name essentially random attendees of a leftist protest based on their appearances or dress by alleging the attendees were the ones who allegedly injured plaintiff, and then permit plaintiff to search through defendant's personal belongings and devices in discovery to search for the identity of the people who allegedly injured plaintiff. Basically, he's trying to suggest that Mr. No could name somebody that he thinks has information that will help him sue other people and use that because he doesn't know who to try to go after, which is a questionable tactic. And then, again, we keep going on a lot of legal explanations for things. And where he thinks that this should be not a valid case to go forward. Things do get a little bit more difficult there, and I have to log in again because of how slow I am reading. Come on. Well, that's not a good sign. State website is going slow. Well, it's trying to see. Let me see if I have the file that I'm thinking of. I might have the next document that I'm thinking of already downloaded. Yeah, so there was a responding motion to strike portions of. Oh, there we go. To strike motion or portions of what I just read off to you, because of essentially saying that they were inflammatory comments. And it does go into a lot of the statements, such as that he appears at the rallies in an effort to dox leftists, that it's well known to people who attend rallies, that he feeds on the attention of the crowd, his belief that racially motivated crimes are hoaxes, and a number of other similar claims. There we go. I think this is the one I want. No, that's not. No. Sorry, there are a lot of documents in this. This is not the one I want. Sorry, there are so many documents in this that it's been difficult for me to figure out what I needed to prepare ahead of time. Yeah, see, this is a lot of where claims that got stricken from the record later says they're conjecture, not personal observations. Basically, like I said, his claims of he thrives off of the crowd's response, or, you know, from reading other stuff, this is how he sees things. And for the record, the judge assigned in this case is Judge Kathleen Daly. She is the one that ended up denying this motion. Okay, so we do have this here. It's defendant's reply from Mr. Bolen in support of his anti-SLAPP motion. Again, this does come into the hearing that itself had happened. Two things are clear from the evidence in the record on this motion. Plaintiff relies on inadmissible and incorrect hearsay evidence to place the blame on Bolen for the alleged punch plaintiff received in a crowd of protesters, and has no other admissible evidence on that point, or he would have submitted it in response to the motion. He did say that some based guy who, again, had posted this information saying he's pretty sure. There is no court record from the person behind some based guy to say, this is what I saw, this is why I believe it's Mr. Bolen. It's just, this is what some random person on the street handed me and said, here, use this in court, but we don't know anything about the person. So again, the only evidence plaintiff has submitted is his own declaration. In that declaration, he relies on hearsay and in his attempt to establish that it was Mr. Bolen that allegedly punched him. At paragraph 7 in his declaration, he states that numerous other individuals familiar with Defendant and his frequent presence at Antifa rallies positively identified Defendant independently, saying he posted footage on his Twitter, and numerous members of the public confirmed that Mr. Bolen was in fact the man who assaulted me. Members of the public were familiar. He'd been photographed fighting both with and without a mask. And this is one of the things that seems questionable, because this particular image was referenced in one of the court filings of Mr. No asking, or saying on May 2nd, this is the unknown masked individual who punched me. So the day of, the day after, he didn't know who punched him, but now can come back and say, oh yeah, it was definitely him. You know, not only are these purported statements by anonymous Twitter users, members of the public, and numerous other individuals hearsay and should be inadmissible, they show that Mr. Bolen was in fact named in this lawsuit because of his frequent presence. Okay. I'm trying to take a look, because there is a declaration that had some very interesting... see if it's this declaration. there is a particular section that I'm trying to find where Mr. No says that he encountered Mr. Bolen at another time in the day on a bridge and had talked to him, and that was part of why he knew that it was Mr. Bolen that attacked him, even though his own tweets from the day of and the day after suggest that he had no idea who supposedly hit him. And that is part of when I think when it comes down to a jury, they're going to end up saying that this seems questionable. And this was definitely something that was brought up by by Mr. Bolen's attorney in the hearing. I'm going to go ahead and just go forward to the actual opinion from Judge Daly. Again, I have gotten the audio from the hearing itself on November 19th. I was able to sit in and listen to that hearing. And while there might be some questions about the judge, it did seem that she seemed suspicious about the case of mistaken identity. But like I said before, it wasn't something that she had the legal ground to reply on. So we do have this that came out, this order came out late December here, after Judge Daly said that she needed time to review the law on this. Said that, the special motion to strike and the cross motion to strike, they both wanted to remove parts of the other's documents. Came before the judge. James Buchel and Harmeet Dillon, pro hoc vice, which means that's pro hoc vice is when there's a lawyer who is not certified to practice law in a particular court, can request the court for a one-time permission instead of having to go through the process of getting bar certification, which can take years to go through. So Hillary Boyd and Jonathan Henderson appeared for Defendant Bolen, and Dave Park appeared for Defendant Hacker. We didn't really hear anything from the Hacker side of the case yet, but he was there for that hearing. Defendant Bolen moves this court to apply Oregon's anti-SLAPP statute. Plaintiff has alleged that defendant assaulted him by way of punch. Defendant alleges misidentification, and the plaintiff is targeting him for being at a protest representing opposing views of the plaintiff. Because state law does not contemplate physical assault as in furtherance of defendant's First Amendment rights to free speech or petition, his motion is denied. And they'll go into later why they applied the laws the way they did. So we have statement of facts. Plaintiff Andy No is an independent journalist who reports on, among other things, political demonstrations in Portland, Oregon. As relevant to this motion, plaintiff alleges that during a demonstration on May 1st, defendant Bolen struck plaintiff in the abdomen with his fist, causing Mr. No significant pain and severe emotional distress. Plaintiff claims defendant Bolen was among the demonstrators and describes Bolen as a heavy-set white man wearing a brimmed black beanie, white frame sunglasses, dark bandana with white patterning, and black gloves with hard extensions near the knuckle area, and carrying a distinctive skateboard. Defendant Bolen does not dispute he was present at the demonstration at the time of the alleged actions, but he denies that he was plaintiff's assailant. The other demonstrators in attendance were dressed predominantly in similar clothing, and the clothing itself obscured any potentially identifying features. Defendant Bolen asserts plaintiff has misidentified him. He moves the court to strike all of plaintiff's claims against him under Oregon's anti-SLAPP statute. Defendant Bolen submits 2 affidavits to support his motion, a declaration from himself and another from journalist Shane Burley. Plaintiff in turn moves the court to strike these declarations as legally insufficient. For the following reasons, defendant's motion to strike is denied, and plaintiff's cross motion to strike is granted in part and denied in part. So again, Mr. No didn't entirely win. There are some things that he tried to get that he's not going to get at this stage. And unfortunately, the things that Mr. Bolen was trying to get, he was not able to, which was removing him from the lawsuit completely. He will, at this point, have to go before a jury, make the arguments, and convince them that he was not the one who hit Mr. No. Now we go into the legal analysis. Saying the anti-SLAPP statute protects defendants from actions arising out of certain statements or conduct by permitting a special motion to strike such actions at an early stage in the litigation. So a defendant may make a special motion to strike against a claim in a civil action described in subsection 2. The court shall grant this motion unless the plaintiff establishes in the manner provided by section 3 of this section that there is probability that the plaintiff will prevail on this claim. The special motion to strike shall be treated as a motion to dismiss, that it may be made under the section against any claim in a civil action that arises out of any oral statement made or written statement or other document presented in a place open to the public or a public forum in connection with an issue of public interest, or any other conduct in furtherance of the exercise of the constitutional right of petition or the constitutional right of free speech in connection with a public issue or an issue of public interest. And there is nothing in here that specifies physical actions. The statute then establishes a two-pronged burden-shifting process, which is, and the first prong in this case, Mr. Burley has to make the case that that his claim is valid. If he succeeds, then the second prong is Mr. No's side has to rebut that and be able to say that even though he makes this good point, we have a compelling reason for this to still go forward. So the process is a defendant making a special motion to strike has the initial burden of making a prima facie, or on the face, showing that the claim against which the motion is made arises out of a statement, document, or conduct described in subsection 2 of the section. Which again, the judge ends up saying that a punch does not qualify. If the defendant meets this burden, the burden shifts to the plaintiff in the action to establish that there is a probability that the plaintiff will prevail on the claim by presenting substantial evidence to support a prima facie case. If the plaintiff meets the burden, the court shall deny the motion. And they shall consider pleadings and supporting and opposing affidavits and stating the facts upon which liability or defense is based. In short, defendant Bolen must first show the claims against him arise out of protected statements or conduct. Only then would the burden shift to plaintiff to demonstrate a probability of success on the claims. Defendant himself admits that a punch to the stomach is not protected. To overcome this facial flaw in his motion, defendant argues that plaintiff's misidentification of him shifts the conduct in question from the alleged punch to the petitioning activity in which he was engaged in at the time. Defendant states via legal brief and affidavit that he was in fact not plaintiff's assailant, and the plaintiff instead named him because of his known presence at and participation in the demonstration, and because of his political beliefs. Because at the time of the alleged assault, defendant was engaged in activity which is protected, he argues the claims against him are covered by the statute. To summarize defendant's argument in terms of statute, plaintiff's claims against him arise out of the protected conduct he was engaging in and not out of the conduct he is accused of, because he was not plaintiff's assailant and was therefore named solely because of those activities. The question of what conduct a claim arises from has been explored in both Oregon and California case law. And they do reference California case law is relevant because Oregon's anti-SLAPP statute is modeled after California's, and therefore California precedent before 2001, which is when Oregon established their version, is binding, and precedent after that persuasive. Persuasive meaning it's not hard and firm, but court decisions in California can be brought up in Oregon as this is a good reason to support what I'm saying. So the Oregon Appellate Court has held that this question is an inquiry into more generally what sort of claim this is. And then she references Deep Photonics Court versus La Chapelle and Mullen v. Meredith Court. In Deep Photonics, as here, the parties disputed what the conduct is from which plaintiff's claims arise out of. In holding that the conduct in question did not arise out of protected activity, the appellate court explained that the act underlying the claim itself must have been an act in furtherance of the rape petition and not just associated with it. Because Mr. No's claims itself is one of assault, battery, and intentional infliction of emotional distress, the conduct Mr. No alleges Mr. Bolen of engaging with is a punch to the stomach. Whether his claims arise out of this conduct or some other conduct of statement is a legal question focusing on what sort of claim plaintiff has brought. In answering this question, plaintiff asks the court to focus solely on that claim. Defendant, on the other hand, argues that the court must consider evidence presented in the supporting and opposing affidavits submitted with this motion. In light of this evidence, he argues the claim arises out of his demonstration activities and political beliefs and not out of the alleged torts or suits. The alleged actions. Defendant Bolen is correct. The California law indicates the court is not limited to the four corners of the complaint in just what is on that one document under the first prong of the analysis. And the court may consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. That prong one does not limit the court to the complaint does not change the scope of the court's analysis. Even though the court considers the facts in the complaint and affidavits, the relevant question for the court, firstly, is whether the claim itself arises out of protected conduct as a matter of law and not whether there is evidence of the defendant's misidentification. Defendant insists that an anti-SLAPP motion is an evidentiary motion. But the Fenton court, citing Fenton and Binda and Keys, noted that the court engages in the evidentiary analysis only once the court reaches the second prong. In essence, they're saying that that evidence would only come into play when the plaintiff is trying to say, I still have a really strong case that I have a very good chance of making in front of a jury. So at the first prong, the court considers only the general nature of the claim itself. Here the claim arises out of an alleged punch to the stomach. Now, I would note, for reference, when I said before about the history of Oregon's anti-SLAPP statute, this does appear to be a California appellate court decision from 2015. So it's not binding court precedents, but it is informative and pretty significant. The judge comes back to the Bolen and Deep Photonics case where the conduct at issue was in furtherance of protected act presented as a complicated question. In both cases, the conduct was closely tied to the expression of protected rights. Bolen held the claim arose out of a news broadcast and that therefore the claim itself was based on conduct in furtherance of free speech. Deep Photonics held that a claim alleging failure to give competent legal representation did not arise out of protected rights because although the claim involved statements made by an attorney, the conduct from which the claim arose was, in fact, incompetency and not the statements themselves. This case is not as complicated. Plaintiff alleges that defendant punched him. The claims of assault, battery, and intentional infliction of emotional distress arise out of that alleged conduct. As defendant Bolen himself concedes, a punch is not conduct in furtherance of free speech. Defendant has failed to make the showing that these claims, as a legal matter, arise out of anything other than a punch to the stomach. The claims against defendant do not arise out of any protected activity, therefore, his special motion fails at prong one of the anti-SLAPP analysis. Because it fails at prong one, the court need not proceed to prong two of the analysis to consider evidence of whether the plaintiff has made a prima facie showing of probability he will prevail. While the court will not reach the second prong, his objection of inadmissible evidence presented in plaintiff's declaration is well taken in part. In paragraph 10 of plaintiff's declaration, he states that the members of the public were familiar with Mr. Bolen as he attended violent Antifa protests and riots in Portland since 2016. Mr. Bolen always brings his skateboard with him to Antifa protests, which he uses as a weapon and to get away quickly from the scene. These statements are hearsay, not based on the personal knowledge of plaintiff, and therefore inadmissible for this motion. The case law and statutory language compel the court to deny defendant's special motion to strike. In denying his motion, the court is not permitting plaintiff to name essentially random attendees of a leftist protest based on their appearance or dress. Rather, the court is holding only that the defendant has not shown that the anti-SLAPP statute reaches the claims against him. Defendant may continue to challenge the issue of misidentification through further motions practice. So again, nothing that has even happened so far has actually doomed the case of misidentification. He just can't do anything about it right now. And we come on to plaintiff's cross motion to strike, which is where Mr. No's attorney tries to get statements by Mr. Bolen removed from the record. They aim to strike them for insufficient evidence, lack of personal knowledge, and inadmissibility. Some of them are granted, and from the declaration of Mr. Bolen, the statements about him appearing at the rallies to dox leftists, that he feeds on the attention even if it's negative, that he believes that racially motivated crimes are hoaxes, that he engages in stochastic terrorism by both demonizing leftists and posting their personal identification. He knows the information is used to target his opponents, has a practice of embedding with a group of people from one of these groups, and reaches agreements with them. He doesn't care about the truth or being accurate, and he's using the lawsuit as a means to raise money, and that he's rushed to judgment with faulty information in an effort to demonize someone with political beliefs that differ from his own. And then there are also statements from Mr. Burley, a supporting declaration, that are also going to be struck from the record. That he uses his clout and funding to identify people leads to a sequence of threats. That he takes an incident, usually something innocuous like a fiery speech at a political rally, and it traces far-reaching allegations, often mixed with opponent's personal information, and the activists fear for their lives because Mr. No wants to make a name for himself. There were a number of other things that he still requested to be stricken from the record that did not go through. And then, so at the end of the day here, defendant's motion to ask the court to apply the anti-SLAPP statute because it's been misidentified, because it does not cover physical assaults, it's been denied. Some portions of the motion to strike are granted from Mr. No and denied for some of them. And this was on December 15th by Judge Kathleen Daly. Oh, again, when you look at Mr. No's Twitter, when this decision was released, almost a month after the court hearing, he painted this as a huge win for his case. All I really see from it is some portions of it were minor victories in that statements about how Mr. No works on an ongoing basis were conjecture and supposition, didn't really have anything to do with the case at this moment. So those were removed for the time being. Mr. Bolen can still come forward with other motions, and I'm not sure if he's going to, how that's going to work, but the attempt to go through everything, and maybe there's another way that he can be removed from the case. There is still, and okay, it's working faster again now. Maybe. There has been some other issues going on. Like I said before, Rose City Antifa was the supposedly overarching organization that was supposed to be coordinating these activities. Mr. Bolen said that the only allegation of his involvement was the allegation of being punched in the stomach. There was nothing about the milkshake incident a month and a half later, the second event, the middle of May, or the gym incident, the middle of May, the Halloween incident. He was not alleged to have been involved with any of those, yet Mr. No has tried to take these 4 different instances and put them all together under this very loose umbrella. There are still some people from the case who have not actually been served yet with documentation because they haven't actually been able to find them. Court filings, I don't know why we're having problems with the court records right now. This would happen, of course. But there are 2 people who Mr. No's lawyers claim are fugitives of the law and are not in the state. I don't have information on hand right now about the validity of that, but Judge Sweet, a different judge in the court, has recently given permission for Mr. No's attorneys to file notice of this case by alternative means, which is taking out classified ads in the Oregonian for a period of a certain number of weeks, alerting the public to this case. Once that happens, then the final people that have not been able to be served, or the individuals, which I believe would be the, according to this here, that's right, there's one name here that I can't see yet. But they will be served by notice in the local newspaper, and honestly, nobody ever looks at those anymore, so chances are they will not know, by all likelihood, and he may well get a win against those people just because he couldn't find them. Additionally, there is still the question going on about the serving of Rose City Antifa themselves as an organization. Supposedly paperwork was served to somebody as an agent, but according to court records, they say that it was a non-party, and they're still officially listed as unserved. So I do not know what is going on with that yet. That little spinny wheel is just bugging me. That's not working either. Okay. So yeah, that is basically what we're looking at right now with Mr. No's case. I'm going to go ahead and work on getting more documents together. Do something of an archive going forward with this, as well as get the audio processed from the court hearing where they made the arguments for getting the case, or getting Mr. Bolen's portion of the case struck. And we will continue watching this case as we go forward and see what comes of it. At this point, I'm going to go ahead and drop off, and we will talk to people later. This is Heather Van Wild with Raindrop Works, signing off.